The other thing in setting up an initial meeting, once we've cleared conflicts and we have to decide whether or not it's the type of case we would take, it's important, and it's also saves time and saves money for the client, that the client bring in copies of all contracts, including any attachments to contracts, if it were a construction matter, any plans or specifications, any photographs that they have, email, dates, timelines that they can put together as to when things occurred. Because a lot of these disputes people do not realize as they've unfolded over a time period, that if you put a timeline together, it's much easier to track what the dispute is and be able to evaluate it. But the contract's the most important thing in all of its attachments, because the contract is the bargain, the deal, the private statute or ordinance, if you will, between the parties, and that's critical. And we have found in many instances that people get into disputes, but they've never referred or consulted to the requirements of their contract when they get into them. So that's the sort of thing that we'll be needing. The other thing to keep into consideration is, the type of case you have. We mentioned before the dollar amount dispute. That kind of goes into guidelines to cases we represent. In our experience, it's virtually impossible to go to trial in a case, even a case that's not that large, for less than $100,000. And we've had cases that have been as much as $2 or $3 million in fees. They're all over the place. In most instances, it's better to try to find a way to get your dispute resolved and not go into litigation if you're dealing with anything under $100,000. Now, we have handled cases below that, but typically we handle those cases in a manner to see whether, as part of the initial dispute resolution, we can assist them in getting a resolution short of litigation. The cases of that size typically are not worth going to litigation because the attorney's fees will end up being as much or more than the amount of dispute. There are exceptions, of course. If you have a right to attorney's fees in your contract as a prevailing party, or a right to attorney's fees by statute, such as under the construction lien statute, then you could fight over a smaller case in court, and if you win, you get your damages, plus you get all or most of your attorney's fees paid back to you. But again, what frequently happens in those instances is the case turns into a battle of who's going to get paid their attorney's fees after you're in it for a while, and that becomes more of the focus than how much you're really trying to collect. So, our general rule is we try to avoid cases that are under 100,000. We do have some long-term regular clients that we will do that work for. They're sophisticated and they understand, the risks of litigating for a lower amount.